So let's jump right into it, everyone. And we're taking you to Plateau State, where things seems to be heating up in the politics, because what has affected the #1 citizen there is definitely getting a lot of ripples. And so the Court of Appeal sitting in Abuja nullified the election of Mr. Mutfwang of the People's Democratic Party as the governor of Plateau State in the March 23 general elections. They're setting aside the ruling of the Election Petitions Tribunal, which had earlier found Mutfwang's election. The court declared Dr. Yowada Nantawa of All Progressives Congress APC as a duly elected governor and ordered the Independent National Electoral Commission (INEC) to withdraw the certificate of return it had given to Governor Mutfwang and issue it to Nantawa. The appeal court held that PDP had no structure to nominate any candidate for the elections, having disobeyed an order of the court to repeat its Congress. Reacting to the verdict of the Court of Appeal, Governor Mutfwang called it a temporary setback, saying it will not distract him from repositioning the state on a path of unity, peace, and progress. He's gone to the Supreme Court now. But there are those who think that that judgment is a variation to some of the similar case as being delivered by the Court of Appeal, by the same court. The same situation, two different judgments. But tonight, let's get some perspectives. The PDP has been reacting to this matter. At some point, the PDP said this is a capture of Nigerian judiciary with the matter of what is happening. And don't forget that the case in Plateau State seems to be quite controversial, quite interesting, because about 7 federal lawmakers have now been removed or been sent packing out of the National Assembly by the courts, and because of similar situation of the internal affairs of the PDP. So there are those who are asking the question, isn't this a pre-election matter? Let's speak with a lawyer who is a former spokesperson of the PDP presidential campaign and Atiku presidential campaign organization in the 2023 presidential election, Mr. Daniel Bwala. He joins us live here in our Abuja studio. Thank you so much, Mr. Bwala, for joining us.
Thank you for having me.
I also mentioned that Bwala is also a member of the Lincoln's Inn. If you have it, sometimes you'll flaunt it. Thank you so much indeed.
Thank you.
It's like being a member of the American bar in any of the states. If you go through the rigor, you'll be able to say that I've got this. Okay. So thank you so much indeed for coming tonight.
Thank you.
There are those who will say that this is a disease, or this is a problem rather, that the PDP brought on itself. What do you think?
Well, if you say that, except now depends on the side from where you're looking at it or the perspective, because again, there are lots of people who will tell you that the judgment of the Court of Appeal is strange. You know, what I mean by strange is because traditionally we know pre-election matters and post-election matters, and that the court, one of the cardinal issues that they raised, based upon which they sacked the governor, was that he violated the order of the High Court that said they should conduct primaries.
In fact, they said repeatedly.
Repeatedly.
Oh, and I mean, that's in fact the perspective to which I asked the question.
Yeah.
That if the court, and it's not the only person that is suffering this, 7 members of the National Assembly of the PDP have been removed, including the very popular Dachong Bagos.
Yeah, ordinarily, election petition being sui generis, as we all know, means that it's a species of its own and should be treated on its own merit. It has procedure that cannot be, related to other proceedings in court. And that election petitions procedure provides the ground for which you can challenge the victory of someone. If you look at the Electoral Act, disobedience to court order is not one of those grounds. So a lot of people who are in the practice of law will wonder that without prejudice, even if the client slapped the judge and the judge gets angry, I'm talking of a worst case scenario, will that amount to a ground for disqualification if the election petition is sui generis? But in their own wisdom, they treated that disobedience to court order, which ordinarily would have been the court dealing on a pre-election matter, as meaning it falls under qualification, which can both be treated as pre- and post-election. That's why they now relate it to 177 of the Constitution. So if the Court of Appeal treat qualification or disqualification as that which can both be decided as a pre-election matter, as a post-election matter, then I'm happy to let you know that, interestingly, the way it has gone, the way of APC in Plateau State is likely to go the way of PDP in the Ebonyi State. So that means the court's judgment is going to come to a point where what is good for Guinea is good for Uganda. Because if you say qualification qualifies as both pre and post, then you need to look at other cases that are in court which have similar flair but distinguishable in their distinctive character, right? Which deals again with qualification, especially if you look at Section 177. You say somebody who is contesting for the position of governor must be somebody who, number one, belongs to a political party and is sponsored by that political party. So if you are not sponsored by that political party or sponsored by a wrong political party, or you have not left your political party the law's way, then they all fall under the qualification. That's what the Court of Appeal is saying. But let me tell you something, Mr. Sheun. Court of Appeal is one. So whether the Court of Appeal sat in Abuja or the Court of Appeal sat in Jos, the Court of Appeal is one court, but for administrative purposes, they are in different judicial divisions. So much so that if you are presiding judge of the Court of Appeal in Abuja, and I appear before you are making a case, and I want to refer to a judgment you delivered in Plateau, I won't say, my lord, your brother judge delivered a judgment in Plateau. I will say, this court, in the cases SP and X, so and so, delivered that. So that means, and the Court of Appeal does not have that benefit that the Supreme Court has, which is that, one, Supreme Court departs, cannot be bound by its own previous decision, right? You cannot use the previous decision of the Supreme Court to say you are bound by that. Meaning that if the Court of Appeal go this way on this matter, on all matters, if the facts are the same or the facts are similar and they fall under the principles of the law, that decision has to go that way.
So in essence, you're saying if you're to look at the Ebonyi PDP matter,
right,
and the manner in which the Court of Appeal had treated the matter and decided the case,
right,
it should be used as the same template, and the same template should be used in the Plateau matter.
Yeah.
Are you thinking that they are not treated the same way?
No, I am saying there are distinguishable facts in the sense that in the case of Plateau, you didn't conduct primaries. Now, conduct of primaries fall under pre-election.
Yeah.
Because you find ground for qualification, ground for disqualification, you find nomination, you find sponsorship, right? Sponsorship is pre-election. But this court says so long as that qualification falls within the purview as covered in the Constitution, it can both be treated as pre and post. Now, if you say this is the decision of the court in Plateau, then you have to apply that with the decision, with the case in Ebonyi. Because what are the facts in Ebonyi? The facts in Ebonyi is that the candidate of PDP went to court and challenged the victory of the candidate of OPC, who was declared winner, as one, that the candidate of APC, as at the time he contested for the post of the governorship in Ebonyi, he was still a member of PDP. Why? Because one, the register of members which was filed with INEC as required by law has his name. Two, he continued to serve as Speaker of the House of Assembly even after he claimed to have defected, but never defected in the open house or in private. Four, he was paying his dues as a member of PDP. Five, even after the election but before inauguration, he continued to act as a PDP member. So in the eyes of the law, he was a member of PDP at the time he contested. Now, if he was a member of PDP at this time he contested, without prejudice to the fact that APC sponsored him, in the eyes of the law, can a candidate who belongs to two political parties contest for an election? It falls under that qualification.
When the Constitution says you must be a member of a political party
and be sponsored by that political party. So he has been a member of PDP, was not sponsored by PDP, was wrongly sponsored by APC. So it falls under qualification. It means that if you apply the principles of the Court of Appeal in Plateau State, then it is the judgment of the court regarding the case in, in Ebonyi is predictable.
The judgment of the appeal court in the case of Governor Caleb Mutfwang was unanimous. meaning that there were no dissenting voices. And immediately they said, look, fine, you got the majority of lawful votes.
Right.
But they upturned the decision of the trial court, which is the election petitions tribunal in the state. But they have also established that with whatever has happened, that the governor was not validly nominated and sponsored by the PDP to participate in that election.
Right.
And you look at the judgment of the appeal court in the National Assembly cases, similar to what they delivered here.
Yeah.
What do you make of that?
So what they are trying to say is that there is a question.
So I'm asking if they have been consistent in the case of Plateau.
If they have been consistent in the case of Plateau, then that means the case in Ebonyi will go PDP's way. That's the point I'm saying. But the distinguishable fact, in the sense that both Plateau and Ebonyi can both be PDP, is that in the case of the Plateau, they also added that he repeatedly, like you said, disobeyed the order of court. Now, if that was the premise for sacking him, the bigger question will be, is disobedience to the court, in the order of the court, one of the grounds that can be challenged? Because if this were to be determined as a pre-election matter, then it can both be determined that way because he disobeyed what the court said, blah, 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 blah. But because election petition is sui generis, without prejudice to the fact that he disobeyed, assuming without considering he did, now is it one of those grounds? Because the court, over and over, the Supreme Court has said, you cannot go outside of the grounds as provided by the Electoral Act in disqualifying the candidate. Why? Because election petition is sui generis. So it will be interesting to see how the Supreme Court will now treat it, whether disobedience to the order of the court to conduct primaries, no longer whether the conduct of primaries pre-election can both be determined. If you go by them, you can be determined both as pre and post.
That was established, amended into the Electoral Act 2022 as to what constitutes a pre-election matter and the time at which that can be determined, and those who believe that that cannot be transported into an election matter.
Yeah, but even though if you look at, I think, section 27.809 of the Electoral Act, where it says the person who can challenge whether or not you are eligible must be somebody who is a member of that political party who has participated in the conduct of primaries. That is to say, if a member of PDP is the one that were to challenge it, he has to show that he participated in that primaries. But they are saying that if you are a member of another political party, you can challenge it under Section 177 and no longer Section 29 or 28 or 29 of the Electoral Act.
Which several times the court has told, especially after the amendment of the Electoral Act, the court has told those who have gone to court in other political parties challenging winners in other in an election, saying, look, this is not your business because it's a matter in that political party.
This Court of Appeal in presidential elections said so. Supreme Court repeated. So, you see, Mr. Sean, our electoral jurisprudence is getting to a point where it is no longer what you know. The court is still predictable, without prejudice to what you know and what is the stare decisis in respect of the matter. And the reason I say that is because at every stage of appeals, you can point at two decisions by the same court that are contradictory. Now, if it were to be Supreme Court, that's why some of us have started advocating that with respect to the Supreme Court, it's about time the Constitution of Nigeria be amended to deal with two issues that makes the Supreme Court sometimes inconsistent in judgment. Because you see, there is one dictum that the Supreme Court is not fallible because it is final. It is not final because it is infallible, but it is infallible because it is final. So if the Supreme Court commits a mistake, that mistake is the law because it's the final code. There needs to be a constitutional provision where you will not leave that latitude and said, if the Supreme Court delivers a judgment that is A, B, and C, the court must be bound if any fact comes to that court that relates to that. Meaning that when you go to Supreme Court and you know there is a legal precedent regarding the matter, both the petitioner and the respondent, both the appellant and the respondent will know the end of the matter. The second one is that the Supreme Court is not bound by its previous decision. Meaning that tomorrow morning you and I can go to Supreme Court and argue on A, and they will decide this way. Next tomorrow, another set of people will come and argue on A. They will refer to this, and Supreme Court say, you can't bind us, and to go the other way. So Supreme Court now, as a code of policy, delivers judgment, but hardly you find justice in those judgments. You won't blame them because they're hiding within the presence of what they call procedure or the law as they deem fit. But then you know the justice of the case is that the votes of the people never counted. Look at the decision of the Court of Appeal in Kano. You know what the presiding judge said in the judgment? He said, where a candidate is carelessly sponsored and nominated by a political party, that selection is a nullity. It doesn't matter if he won the highest votes.
So it's on technicality that such a candidate will be uprooted out of the race.
Yes, when they say it doesn't matter how many votes he won, then that means no longer the wishes of the people. That means it's technical procedure.
But does it also speak to how politicians and political parties also conduct their own affairs? Because if the PDP had put its house in order,
right,
the man who had won this case, this governorship election with over 500,000 votes, will not be in any legal quagmire. He will be sitting pretty, other than having a situation where his election is now being threatened by the technicality of what his party did and did not do at the primary level.
But in the presidential election, PDP put his house in order. Did the PDP win? So this is my point. And I'm saying that our eyes are now, they hate it when you say all eyes are on the judicial.
Are you saying that, things are being, they are confusing the manner in which the court are deciding?
The court is more unpredictable as the days go by. Now, let me tell you.
Based on how the law is.
Yes.
There is the way the law is and the way the law is ought to be.
Yeah.
So sometimes the manner in which the law is right now.
They give it to you like that. Now, but sometimes in the past, Supreme Court being a court of policy, when they look at it, they will say the mistake of somebody cannot be visited on the client. That means we are not going to be bound by technicality. We'll look at the substance of the case. They've done that several times. Then there are times they will wake up. It's like somebody waking up in the morning. He feels good. He does something, he works, or he feels somehow, he does the other way. Either way, you don't blame him because he has something to back it up. Right? So if it is justice, then it should be not just the law as it is, but looking at the intention of the lawmakers, looking at what is the overall objective of election, that the voice of the majority should bring the person. Right? Now, but the biggest culprit, the biggest evil in the 2023 election across all levels is INEC. Because have you seen the mystery of INEC? In my practice of law, let me tell you, there are times you appear in court, right? Maybe you tender a document from the bar, and in the course of proceedings, you now object to that document. The court will draw attention. They say, Bwala, do you know the implication of what you are saying? The document you tendered, you are objecting to it. The court is trying to tell you, are you okay? But in this 2023 election, INEC will certify a document for you. INEC will be in the court raising objection, and the court has never cautioned them. So we will get to a perfection, but this election regime has left so much to be desired. But my eyes is focused on Ebonyi. Because if the way the judgment is going, parties are saying this is -1, we score 1 goal, this one we equalize, we score, you equalize, then if you are saying that we have an own goal in Plateau State, we score a valid goal in Ebonyi State.
What do you think, legally and politically speaking, are the implications of this Plateau governorship tussle?
This is what I think, that if the Plateau State governor goes to the Supreme Court, because certainly with this judgment, there are so many issues to be tried. There are questions that the Supreme Court will determine, right? No, since 1999 till today, there is no jurisprudential law that has ever gone, in my view, maybe I don't know, to the Supreme Court where in election petition, the court invalidated the victory of a winner on the ground that he disobeyed the order of the court in a pre-election matter. So this is germane, this is new, this is novel. It will be interesting to see how the Supreme Court delivers. And if the Supreme Court will be careful about the consequential effect on cases all across Nigeria.
And of course, there are those who believe that as a court of policy, the Supreme Court might be very careful in removing or sitting a governor.
I don't think that the Supreme Court has ever been that frightened. What they do is that they sit, if your facts are not, when you make your case, the options are two. They look at, they glean, they look at, usually they are to try the decision of a court below. It's not a trial court that you will start putting a lot of blame on them. And usually when appeal comes to them, they will either say, we agree with the judgment of that case, or I will give you a good example. In Hope Uzodimma's case, you know, a lot of things were said to castigate the Supreme Court because it has never happened. But if you look at the Hope Uzodimma's case, it is very similar to the decision which favored PDP in Nasarawa State. Because the plus and minus which INEC refused to do is what the tribunal did, for which they now removed the governor and then endorsed the candidate of PDP. So that's how the Supreme Court is. You have to understand them. There are times because people who are not lawyers, they may not understand because everybody wants justice. But those of us who practice the law, we don't just follow emotions. Sometimes we look at the law, and it is our duty to also advise. I don't personally believe that every case that the Supreme Court decides, what you will come again and say they collect money. And by the way, critiquing the judgment of the Supreme Court is permissible. I have had a lot of platforms where lawyers threatened the legal profession and say, don't ever criticize the decision of the Supreme Court. No, the law develops from the time immemorial, from critiquing of the decision of court. If you go to England, the jurisprudence of law developed from that. But what you must not do is to castigate the integrity of the judges. Right. So I can decide, I can criticize the reasoning of your decision without impeding on your integrity.
So, I mean, on a final note, where do you see this going? It's going to be a lot of lesson for our electoral jurisprudence on one hand, and our politics in Nigeria. Where do you think, because on the street of Plateau, there are protests.
Yeah. I would say the people of Plateau should be hopeful, because we have never seen where election was invalidated on the ground that somebody disobeyed court order. If you look at the ground in section 134, disobedience to court order is not there. Now, the court can say, no, disobedience to code of conduct was a consequence of not conducting the primaries that we say you should do. Even if they don't conduct the primaries, right? It is pre-election, but it's more of the disobedience of the court. So they should be hopeful because the court can give that. But our eyes as PDP, because it's now it's now a situation that of plus or minus. Our eyes are now fixated in Ebonyi, because if this goes this way, then we have every reason to believe that Ebonyi will go in favor of PDP. And don't forget, in Ebonyi's case, even the governor, Dave Umahi, who now is in APC, when he defected, some people went to court to say, we remain the members of PDP. That candidate that eventually ran on the platform of APC, he was among those persons. So can somebody, very unique again, the case of Ebonyi too, can somebody be sponsored by two political parties? No. Can somebody be sponsored by a political party when he has not in fact left the other party? No. The third one, can somebody in apparent disobedience to the procedure of election maintain membership of a political party, run under the platform of another political party? No. Right. And all of these things fall under qualification.
Daniel Bwala, thank you so much indeed for your time tonight. I appreciate your perspectives and the analyses that you have given in these very heated political situation in Plateau. Thank you so much indeed for your time.
Thank you as well.